Again, as we're approaching Halloween, you'll probably see some press-related types of activities for registrants in your communities that prohibit them from being in certain locations during Halloween, or maybe turning on lights, or maybe they all have to go to a meeting or so forth. But that's all tied to registration activities. And so we're going to go through some of these details. To be honest, it's a very convoluted process that changes all the time, and it's greatly impacted not only by legislative changes, but by court cases, right? There's a lot of litigation, there's a lot of challenges to these efforts. And for that matter, there's actually one recent challenge. We'll get into that a little later, where the state lost, and it will have a significant impact on individuals required to register in the state. So, to begin this section, I always like to throw up just this information about the two individuals that our registration system was named after. So you can read the details here on the screen, but both situations obviously were very bad situations. In each case, the individual was murdered. So both Zachary Snyder and Stephanie Wagner were both murdered. But the Zachary law piece of this ties to the sex offender piece of our registry, and the Stephanie's law piece ties to the violent offender piece of our registry. And again, I will explain that as we go through the registry. But I would encourage you, if you're talking about sex offender registration activities or sex and violent offender registration activities, never forget the names. And when I typically talk about this, I'll say, Indiana Sex Offender Registry, Zachary's Law. It helps people to not forget, if you will. So again, I would encourage you to use those names in the future if you happen to be talking about our sex and violent offender registry. So who's required to register in Indiana? I think most of these offenses will be probably straightforward. Not all, but most of those will be straightforward. First of all, kind of starting at the top of the screen, adults and juveniles convicted as an adult will be treated as an adult in our system. So if you have an adult that's convicted of rape, on average, they're going to be required to register. If you have a juvenile that's waived to adult court and convicted of rape, they're going to be required to register. And so all of these offenses will lead to that registration requirement. However, one of the challenges with this is the individual had to be on notice of that obligation to register. So while we list all of these offenses on your screen, not all of these were available day one when Indiana started its registration system back in 1994. Only roughly maybe 8 or 9 of these were available. So the rest of these have been added over the years. And if the offense was added after a crime was committed, then because of various cases that have come down, it's going to be an ex post facto violation of our Indiana Constitution, and the individual is not going to have an obligation to register. So we'll get into some of those details a little later, but to begin, these are the offenses that require registration. Attempts and conspiracies of these offenses will require registration as well. They're treated the same way. Crimes from another jurisdiction that are equivalent to any of these offenses will lead to a registration obligation as well. And individuals that are actively required to register in any jurisdiction will also be required to register. And I want to stress the word actively, and I'll get back to that as we proceed to the presentation, because that is where there's been some recent case law that has significantly impacted our registration system. So looking at the list, again, most of these offenses probably do not surprise you. I think we would all agree that if somebody's convicted of rape or child molesting, we probably expect them to register as a sex offender, right? But there are some offenses on this list that may not be so straightforward. So for those of you that are familiar with sex offenses, with kind of the Indiana Code model of this, you'll probably recognize that sexual misconduct with a minor, there is a level 6 felony. And under old code, there was a D felony for sexual misconduct with a minor. But yet, if you look at the screen, neither level 6 nor D felony is listed, right? And so even though if you read the words under Indiana code for that offense doesn't require registration. So if you have an individual that's convicted of sexual misconduct with a minor, level 6, that individual will not be required to register in Indiana for an Indiana obligation. A couple of other kind of unique things about this. You don't see voyeurism. Voyeurism is not on here, right? So voyeurism is not a registration offense here in the state of Indiana. So if an individual gets convicted of voyeurism, they will not register as a sex offender. Couple of other unique things. We have criminal confinement and kidnapping. You can see the qualifiers there. The victim has to be less than 18, and the kidnapper or the person confining the individual can't be the parent or guardian. So if it's a domestic situation, then that's not going to lead to a registration if they happen to be the parent or guardian. But if it's not, and the individual is not a parent or guardian, and the victim is less than 18, even if there's no sexual element with the kidnapping or criminal confinement, that doesn't matter. This individual will be defined as a sex offender in the state of Indiana. As you can probably imagine, we do get challenges on that quite often because that confuses people, right? They get convicted of kidnapping. It was a carjacking. One of the children in the car was, 13, which is certainly less than 18. They get convicted of that offense because, the extra steps of kidnapping are involved. They go through the justice system. The court may not even be aware. The prosecutor may not be aware. His counsel may not be aware. However, because he's convicted of kidnapping and the victim was less than 18, he is a sex offender in the state of Indiana. So again, the point of this screen in this slide is to simply say if an individual is convicted of one of these offenses, then they're likely required to register. If they're not convicted of one of these offenses or one of these conditions, then they won't be required to register. Final example before we move on. So it's not uncommon an individual be arrested for rape. Later on, there'll be some discussion, maybe a plea. Maybe it's pled down to sexual battery, which would still be a registration offense, but it's not uncommon to see ultimately that pled down to battery, right? Or the offense changed to battery. Even though that individual was arrested for rape, they will not have a registration obligation if they're not convicted of a sex offense. So if that is reduced to battery, then that individual simply will not have an obligation to register. We do have individuals that are identified as sexually violent predators here in our state. I'm going to distinguish this a little bit from how other jurisdictions typically treat predators. Many states will have more of an assessment-based model or maybe a sex offender management board that makes that determination using all kind of predictive tools that they believe are validated for their populations, right? That's not the way it works in Indiana. In Indiana, if an individual has been convicted of rape and they were on notice of a registration obligation, they will be a sexually violent predator. If an individual has been convicted of child molesting, same thing. They will be a sexually violent predator as long as they were on notice. In other words, they committed their offense after June 30th, 1994. So we have an offense-based model that if you're convicted of one of these offenses, a court does not have to make a determination that you are a sexually violent predator. You are a sexually violent predator by operation of law. Now, that doesn't mean an individual that commits one of the other sex offenses from our previous slide, for example, sexual misconduct with a minor. You don't see that on this list, but yet that individual could be determined to be a predator. But for that to happen, there needs to be a special court hearing as a part of his conviction that determines that he's likely to repeat these types of activities. And there's other qualifiers that go along with that as well. But basically, the court is then going to make that determination that he's a sexually violent predator. So we really have two models here in Indiana. One is offense-based. If you commit certain offenses, you are a predator. If you commit offenses not on this list, a court can still determine you to be a predator, but there is a process that has to be followed for that to occur.
Brent, we have a question in the chat, and the question is, what is criminal deviant conduct?
Okay, interesting question. We'll go to this slide here. So criminal deviant conduct was removed from code, I believe in 2014 when code was recodified. The elements now of criminal deviant conduct are included under our rape statute. So there was overlap between those two statutes. And so instead of having two different ones, they were combined into one. So really, what is criminal deviant conduct? Basically, it's not traditional intercourse, if you will. It's kind of everything else you would think of, right? There's going to be some of those types of activities that play into that. But again, so if individuals still have those convictions, certainly, and we still have people in the Department of Correction that have those convictions, then when they get out, they're still going to be required to register, even though you couldn't be convicted for committing that offense today. For those types of activities, you would be committed under rape or
We,
convicted of rape.
we
And
also have
follow,
a
oh,
question, sorry, just about definitions of vicarious sexual gratification at various levels. Is there a resource where people can find definitions for these terms?
yeah, absolutely. So I will give you a little detail about that, but also before I get into that, the resource for that is really Indiana code, right? All of these terms are defined in Indiana code. It's all laid out. What I would recommend you do I suspect most don't have access to Westlaw or LexisNexis. If you do, and you have access to those legal research tools, you can certainly look this up. If you don't have access to that, the Indiana legislature under in.gov. So if you look for Indiana code for Indiana, there should be a link that comes up that will get you to the legislative site where you can actually search any Indiana code. And the particular section that you would want to look for to see how criminal deviant conduct's been defined in the past or how vicarious sexual gratification is defined today, you would look there and you would search under 3542.4. So 3542.4, so 35-42-4 are the sex offenses for the state of Indiana. Now, again, our registration model goes beyond that section, but that'll give you the information for the items that you're looking for here. So vicarious sexual gratification, it's really, in a very general sense, it's encouraging others to do sexual types of activities for your gratification. That's really what it comes down to. And again, you can see those definitions in that. And it looks like there's a comment that there'll be some training on this in the afternoon. So good opportunity to get a little more detail about that. So length of registration. So we have certain individuals that commit certain crimes that are required to register. Some of those individuals are predators. And now, how long does an individual have to register? So Indiana really has two models. We have lifetime requirements. We have 10-year requirements. There is another caveat to that, but I'll get into some of that here in a second. So individuals that are going to be required to register for life are people that are predators, either by operation of law or have been found by a court. So they're going to be lifetime registrants. If a crime has been committed against a child under the age of 12 and the victim was 18, then that individual is going to be required, or 18 or older, that individual is going to be required to register for life as well. If the individual is caused bodily injury or death, used force, threat of force, or they've rendered their victim incapable of giving consent, rape, drug, for example, that's going to be a lifetime registration requirement. In addition, if the individual has two unrelated offenses, two unrelated under a certain model will require you to be a predator, but there are situations where two unrelated offenses will not make you a predator, but yet will still make you a lifetime registrant. So the idea here is that, these are crimes against younger folks, or there was more to the crime, for example, force or threat of force or rendering, that require lifetime registration. If an individual does not fall under that model, then typically they're going to be required to register for 10 years. And that 10 years is going to start when the individual is released from a in custody status or placed in a program, whichever occurs last. So to give you an example of that, maybe an individual is coming out of the Department of Correction, maybe he served 10 years, he's released to a community corrections program for 2 years, and then he's going to be placed on probation after his community corrections participation, right? So that time he's incarcerated, well, obviously that doesn't count towards his tenure requirement. His community corrections may be an in custody piece as well, or maybe not. Maybe it's more of a work release type of activity, but he's not going to get credit for that either because he has a probation entry following community corrections. So technically, that individual would serve his time. He would serve, for example, 2 years on community corrections. Then he'd be placed in probation, and his 10 years would start when he enters probation. But yet he might actually register for longer than 10 years because he's going to have to register while he's on the community corrections program. In addition to that, kind of going back to the violent offender piece of that we talked about early on, the violent offender piece of our registry only applies to murder and voluntary manslaughter. Those are the only two offenses. So again, kind of going back to that discussion for criminal confinement and kidnapping, those are sex offenses. So the only two violent offenses are murder and voluntary manslaughter. Because of the way Indiana code is written, frankly, because of an editing mistake in Indiana code, on average, individuals that are convicted of these offenses are going to register for 10 years. And the reason for that is because the whole use of force, threat of force, that provision can't be used against violent offenders. Now, if they do have a victim under the age of 12, they can still be required to register for life. If they have unrelated offenses, they can be required to register for life. But if it's simply because of bodily injury or death, which by the very nature of murder and voluntary manslaughter, there probably is bodily injury and death, they cannot be required to register for life. So over on the right part of the screen, we can require an individual to register for an other jurisdiction requirements. As an example, if an individual comes to our state from another state and they're required to register for life in that state, we're going to look to see what their equivalency is here in Indiana. And if their equivalency would not be life, then we would take the longer of the two, which would be life from the other jurisdiction. This provision as well is impacted by that recent case law that I mentioned. And again, we'll get into that because there's definitely some limitations to this now. Final 2 points on here. So if an individual is jailed or incarcerated during the registration time, well, their clock stops, right? We're pushing pause, and they are not getting credit for the time they spend in jail, at least for a registration perspective, right? So if an individual had a 10-year registration period, they had registered for 5 years, they got arrested for whatever, it doesn't have to be a sex crime, it could be anything. Maybe they committed a DUI, and now they're going to be in custody for a year. When they go into an in custody status, their registration period stops. When they come out of that in custody status, it picks up where it left off. So they do not get credit for the time they're in jail or incarcerated. And then the final part on here, we've had some new legislation passed a few years ago now, but individuals that have recent failure to register convictions here in Indiana will be given a new registration period to go along with any existing registration period. So if you have an individual that's required to register for life and he fails to register, there's no new period you can give somebody above life, right? But if an individual is required to register for 10 years, let's say they had a failure to register last year, upon their release, we're going to look at their case, we're going to make a determination, and per Indiana code, we can, and we do, add a new registration period, which would be another 10 years. So that original 10-year registration period is now a 20-year registration period. So again, predominantly 10 years in life, but we do have various amounts of time in between, either from another jurisdiction or because maybe time is told or because they have a new failure to register conviction. So we do have an administrative procedure for individuals that are required to register. So before they get out of the Department of Correction, they are provided notice of their obligation to register. That individual's given to, or that obligation is given to them in person. As a result of that information being given to them, they can challenge that if they believe we're wrong. We do get many challenges. For the most part, those are all denied because we typically get reasons that they don't want to register is because I don't want to register. And that's not good enough, right? A successful appeal to that procedure would be you didn't have all the details on my crime and I actually wasn't convicted of this offense. But those aren't typically the appeals we get. The appeals we typically get are, well, I didn't really commit the crime. I've already registered for a while. I don't want to register anymore. Those are going to fail every time because, again, they're not based on any factual issue that we can check. It is what it is. In addition to our procedure, there is a local procedure that is available to individuals that are registering with your local sheriffs around the state. In that process, it's a two-step process. So they would protest with the local sheriff. If the local sheriff does not agree with them, then they could appeal to our office. Again, many of those challenges are going to be the same type of thing. I've made myself better. I've been rehabilitated. Well, again, none of that's eligible for relief under Indiana code. It's simply, is there a mistake or is there not a mistake? That's really what we're looking for. But the point of this is that individuals do get notice before they are required to register, and they do have the ability to question and challenge that obligation, or if they think information that's presented publicly to them or about them is incorrect. So they do have those abilities. So one final piece on this, and we'll kind of go to a different section of the registry piece. There's a lot of requirements for registrants. Within 72 hours of release, if they're a predator, they have to register with the local sheriff's department. If they're not a predator, they have 7 days to register. So those are typically 10-year individuals or individuals that are life but not defined as a predator. They have to register in every county where they live, work, attend school, and own real property. So if those are all different counties, then they have to register in multiple locations, and it is their obligation to do that in person. If they make any change to any data point that is collected as a part of registration, if you are interested in looking at our registration statute, you can certainly see that under Indiana Code 11-8-8. If they make any change to any of the data that is required for registration, they have to report that change within 72 hours. If they don't do that, or they don't report to the appropriate counties where they're supposed to, or they don't report in the appropriate number of days, they can be charged with failure to register, and that's a felony here in the state. In addition to that, so if any of these changes happen, they have to report, but in addition to that, they are obligated to report periodically to the sheriff's department just to update their information in general. So a predator has to report every quarter, so every 90 days, and a non-predator has to report once per year. So there is going to be at least one or four contacts per individual every single year. But for the most part, with this population, they do change addresses, they do change appearance, they do get social networking identifiers. Maybe they join Facebook, whatever the case is, they have to report all of that information. And again, all of that has to be reported within 72 hours. On the opposite side of that, local sheriffs have obligations here as well. So when an individual registers with their department, within 7 days of that arrival, they have to go out and validate where that individual is living. So they have to actually make sure they are living where they're located. They have to go out and visit these individuals again on that kind of same cycle. If it's a predator, they're going to go out and visit that individual 4 times per year, every 90 days. If it's a non-predator, they're going to go out and visit once per year. So there is a lot of contact with local sheriff's departments and the registered sex or violent offenders within their community. And again, all of these requirements would be outside of any supervisory obligations they have for probation, parole, community corrections, and the like. So these would all be in addition to that. So one of the other things that we handle a lot of in our office is our court cases. So we're responsible for that. We work with the Office of the Attorney General predominantly to represent us in these cases. There are a ton of these cases. We've been challenged over and over and over for many, many years. And on the next slide here, you'll see this is just a sampling of the cases. It certainly is not exhaustive, but see, these are some of the bigger cases in each of the areas listed on your screen there. But this area is heavily litigated. If you look at Indiana code and you look at the requirements without looking at these cases and many, many more, you'll never truly understand registration. So this is a very challenging area that is very code specific, but also case law challenging. We're going to get into one example. So before we move on, it'll be under the other jurisdiction requirements towards the bottom of the page here where it says Peters and Mariquin. So those are the two cases. Peters comes from Hamilton County. Mariquin was actually against the DOC, but I believe he was up in Northwest Indiana. And so these are cases that are very recent, that were recently decided by our Indiana Supreme Court and will have a significant impact on our registration efforts going forward. So just to give you kind of an analysis of that case, we won't talk about any of the others. Predominantly, the decision came down in Peters. And it was basically how we make determinations that an individual is required to register and what information we can use. So if you remember earlier in the presentation, if an individual comes to our state, they might have an obligation to register in another jurisdiction, or maybe not, or equally so, maybe their offense is equivalent to an Indiana offense. So they've committed a crime in another state that's equivalent to rape here in Indiana. Well, we can use our rape statute and we can apply what would be applied to them if they had committed a crime in Indiana. But we could also historically take the other jurisdiction's requirement. So Indiana Code 11884.5 and 19, you'll see snippets, a couple of sections there that are important in this court case. So under 4.5, this is a definition of who a sex offender is in the state. So it's not only an individual that commits rape or child molesting or sexual battery or sexual misconduct to a minor, but it's also a person who is required to register as a sex offender in any jurisdiction. 118819 will get into the length of requirement. And again, so this is going to be the section that says the guy is required to register for 10 years or life or some other other amount of time. This particular item F, a person who is required to register as a sex or violent offender in any jurisdiction for the period required by the other jurisdiction or the period described in this section, which is Indiana, whichever is longer. And then there's some cases cited under there. Those cases were state level cases, but then later we had new state level cases, Peters and Mariquin, that certainly impacted this. So what did the court say? And again, specifically focusing on the Mariquin piece in this code. If you look under that statutory language above, again, you'll see a person who is, and I stress is because that's the most important word here, required to register. And if we think of is, that means present tense, right? So he is required to register today. So in the Peters case, he was actually an individual that committed his crime in Illinois, was required to register in Illinois, came to Indiana, was required to register for the same length as Illinois, which was 10 years. Later on, he went and vacationed or stayed for a period of time in Florida, picked up an obligation to register for life because of that Illinois offense in Florida, and then moved back to Illinois. So when he moved to Indiana, after that vacationing in Florida, he had a lifetime obligation. So was he a person who is required to register as a sex offender in any jurisdiction? We said yes. Did he have a longer obligation in another jurisdiction? We said yes. What the court said is that is present tense, and once that person leaves the other jurisdiction, his obligation with that other jurisdiction effectively lapses or stops, right? So he no longer has that obligation. He did, but now he doesn't. In addition to that, register is defined under Indiana code. It's very specific. An individual has to report to a local law enforcement authority, and they have to provide a bunch of data points, right? So our court disagreed with our interpretation of is, but in their analysis, even if they gave on that whole is issue, their problem still was, how does he actually have to register and report all this information to the local law enforcement authority? So we lost this case. And there's various impacts to this. Certainly, if an individual goes to Florida and he leaves, there is no ongoing active obligation to register. What about an individual that registers here in Indiana, but also has a property in Florida and spends the winter in Florida, and then goes back and forth between each jurisdiction? Well, we can use that other obligation because he is required to register in the other state. So in a nutshell, this has limited the individuals that we can use the other jurisdiction requirement for. And now we're limited to simply looking at an equivalency. Where this becomes very challenging is if you have an individual that was required to register in Florida. He no longer wants to register for life in Florida. Crime was committed long ago, so it's no longer under our registration model. It might be equivalent to one of our offenses, but it was only a 10-year offense. So he's living in the state of Florida. He sees that Indiana has a less restrictive obligation for him, so he moves to Indiana, and he's no longer required to register. That is happening very frequently now. So this case has tremendously impacted our registration obligations. We got a call from an individual required to register within 2 hours of this case coming down. So certainly this information was being spread among the registration population, not only in Indiana, but frankly around the country. And if you do some research on some advocacy groups for registered sex offenders, you will see reference to this case and that Indiana is less restrictive on individuals moving from other jurisdictions now. So with all that said, can Indiana fix this issue? Certainly. Matter of fact, our Supreme Court even wrote information in their opinion, basically saying the legislature was free to change the code, right? So if you look down at that bottom paragraph, that's basically a statement that came out of, or at least the logic of it came out of the opinion. So if we would change our definition not only to individuals that have committed rape in Indiana or committed child molesting in Indiana or committed sexual battery in Indiana, and in addition, or had an obligation in another jurisdiction, current obligation, right? And then added language that basically said that that sex offender definition also included individuals that previously had an obligation or would have an obligation if they went back. All of a sudden, our definition is much bigger and we wouldn't nearly have the same issues we have. So with that said, that's the type of analysis that we have to do or every single case that comes down, and there are a lot of them that come down, and we have to analyze those. We have to work with our counsel. We have to work with the Office of the Attorney General to figure out, basically what are the next steps. In addition to that, as we all know, a new legislative session is coming soon. And so I would guess there'll be some interest in this issue. And so we may see some changes to this as well. But in any event, as of today, there are challenges applying other jurisdiction obligations to an individual that relocates to Indiana. And as a result of that, certain individuals that have lengthy registration obligations in other jurisdictions may have lower obligations in Indiana or no obligation at all. So moving on, we certainly deal with Indiana code changes. I just mentioned, that will likely be an issue that is at least discussed in the upcoming session. But each year we go through code. We certainly are aware of what's going through our legislature, how it's going to impact our efforts, and we look to see what that happens to be. So I have one example of something that changed this past session that became effective, I believe, July 1st of this year, that impacts where individuals can work that are required to register. Before I move on, I want to read a question in the chat here. Do you think that we'll have more offenders moving to Indiana to get that lower registration period? Absolutely 100%. We're already seeing it. Okay. So jumping back to this was a code change this year. This is something that was modified. So giving you kind of an overview of some of these requirements. Certain individuals, not all individuals that are required to register, have prohibitions on where they can live, where they can work, and in some cases, even where they can be. So this particular statute, 3542-410, says that certain sex offenders, those that are required to register, those that are predators, those that are offenders against children, and those are both defined again by Indiana Code. We looked at the predator definition. We did not look at the offender against children definition, but there is a list of offenses that go along with that. But if an individual falls in those categories, they can't work on school property. They can't work at a youth program center. They can't work at a public park. They can't work as a child care provider for a child care provider, or they can't work as a provider of respite care or adult types of services, daycare types of services. I think everybody would agree that's probably commonsensical. We don't want individuals convicted of sex crimes in areas where there's going to be children or people that can't care for themselves, right? In this legislative session, the legislature went a step further and they wanted to close more holes, if you will, or gaps. And I think they've done that by item 7. So this is the new piece that was effective July 1st. So in addition to all those items above, it also prohibits an individual, again, a predator or an offender against children, from knowingly or intentionally working in any setting where the sexually violent predator or the offender against children has more than incidental or occasional contact with a child who's not accompanied by a parent or guardian, has supervisory or disciplinary power over a child, or is expected to touch a child on more than an incidental or an occasional basis. So again, our legislature tried to further define this area and close really any gaps that existed. So again, this is the type of thing that we do with the folks that we work with and the information that we have to provide. And we'll get into some details on who those folks are in a minute. We also have various grants and contracts. That's another part of the division here in our registration and victim services division. In the Department of Correction, we have a variety of grants ongoing at any given time. Currently, we have 3 Adam Walsh Act grants used for a variety of different purposes, and I'll give you some examples. We have applied for a new one this year, so we're hoping to see that grant. I think, as we all know, federal granting efforts, of course, at the federal level have slowed down quite a bit. Some of them are not moving very quickly at all. We anticipate we actually will have a good opportunity to get this award. In years past, technically, it would have started October 1st, but I don't even think the applications have been reviewed at this point. So hopefully we're going to get it. But again, things are a little slower at this point. We also get SORNA reallocation grants. These are penalty funds from the state that come through the federal government. So some of you may be aware of this. Many of you probably will not. One of the grants the Indiana Criminal Justice Institute gets is what's called the Justice Assistance Grant, JAG. And typically funding goes from that to local law enforcement to do a variety of things. Well, if a state is not pliant with the Sex Offender Registration and Notification Act under the Adam Walsh Act, Sex Offender Registration Notification Act, or SORNA, is the federal registration requirement. There's 17 states that are in compliance with those requirements today. Indiana is not one of those. So we are not in compliance. And as a result of that, then our state is penalized 10% of its JAG award. However, we can get those funds back to the state, but they have to be used specifically for registration. So that is what the SORNA reallocation grants are for. And then we have various contracts. We pay for the sex offender registry. We pay for the Department of Corrections live scan efforts or fingerprinting efforts. So we pay for all of that. We have agreements with the courts. We have agreements with B&B. We have tons of different agreements of entities that either have interest in or we want to partner to leverage their data for our sex and violent offender registration activities. Our grants have been used for a ton of different things. And across the board, we funded applications like the registry. We've added to the registry. We provide local law enforcement with tools. So we've certainly provided cameras and scanners and iPads and all kinds of things. But predominantly, one of the bigger areas where we've actually used a lot of these funds is really to increase our capacity. So we've brought in a ton of people on contract. We go through a state vendor to do that, but we bring folks in to individuals that are required to register, collect data on individuals that are required to register, and so forth. So we certainly have leveraged federal granting efforts to our benefit to improve the state's sex and violent offender registration efforts.
And Brent, we have a question about these grants really quickly in the chat. So, does this mean if these grants are not approved, some of us do not have a job?
Well, I mean, I guess now in our situation, these are very specific, but yeah, I mean, I think everybody can agree on this call or on this training that has anything to do with grant funding, that if you don't get grant funding, your program may end if you don't have another source of funding for that program, right? Certainly from a victim services perspective, this is very challenging. Most of those entities, they're not a large organization, right? They don't have many staff. And so typically federal funds or just grant funds in general are used to support those. And if those funds dry up or they're not awarded, those programs may disappear. If a local sheriff's department or a local law enforcement agency doesn't get a grant, they may not be able to do that service, but they're not going to close the door, right? So there are differences and there are some very significant challenges for entities that are grant funded and kind of taking that to the next step. That's one of the reasons grantors always ask, how are you going to sustain your program, right? So when the grant funds go away, how are you going to survive? And so hopefully most programs have really put serious thought into that over the years because, this is one of the challenging times where money is just simply not as available as it has been in the past. And I think if you look at the comments, that's a perfect comment with the domestic violence program. And I think that will likely happen for many. And so sustainability is a key. You really need to figure out how you can survive without money from other organizations. Okay, so moving forward, try to keep us on time here. We do have a committee that we work with to do these efforts. So we provide our determinations, but we provide a lot of assistance to the population that we partner with. And our group that we partner with are local sheriffs. So here at the Department of Correction, we make decisions on who is required to register, who's not required to register, their requirements that they have to adhere to, those types of things. But we do not go out and we do not register these individuals after they leave DOC. So we do register them before they leave. But once they get into that local community, we don't have the staff, nor do we have the enforcement power, right, to enforce registration obligations. So that's where your local sheriffs come into play. So we partner with local sheriffs in every county. Every county has what we call a registration coordinator. That's somebody that's assigned to registration efforts. In smaller counties, that may actually be the same person that investigates a sex crime. So that may be the detective that would investigate a rape offense or a child molesting offense. In larger counties, there's probably going to be a differentiation between responsibilities. So you're going to have people that are dedicated to registration. You're going to have people that are dedicated to sex crimes investigations and so forth. But at the very least, there's one individual in every county, and in many counties, there's more than one individual that we work with. But as you probably can tell going through this presentation, this is not easy. There's a lot of details, and we've only touched the surface. And so we need to provide constant training to these individuals. And we need their assistance to help us make sure that we're all working effectively together. So we do have an SVOR committee. We have various projects that we're working on with them, ranging from where we create policies and procedures. So how do you actually do registration? What's the expectation for your what if a new person comes in today that has never done this? How do they actually learn, right? So we create policies and procedures, and we also design forms. So registration, much like everything else, people want documentation. When you go to court, it's great to have paper. It's great to have somebody's signature, right? And so we create a lot of forms that are used by local sheriffs when they're registering individuals in their community. Just to give you a couple of examples, we have that appellate process before an individual gets out of DOC where we're putting them on notice of their obligation to register. Well, absolutely, we're getting a signature from them that they acknowledge that they got that determination and they understand they have a right to challenge that. That's a very good document to give a prosecutor if they fail to register, right? When they leave DOC, they sign a registration form just as they would sign a registration form in a local sheriff's department. When they change an address with a local sheriff, there's a change form. That information, again, is documented on paper. They want a signature from the individual. So, bottom line is there are tons of forms, and those forms are used against the individual if the individual does not comply with the rules. Of course, we do have individuals that don't sign their forms. They refuse to do that. Well, there's mechanisms to deal with that. We can have witnesses sign, and again, they might have to testify, right? The witness might have to testify, but ultimately, this is to ensure that these individuals are complying with Indiana code. We also assist counties with their kind of data collection efforts, NCIC efforts. We recently, as a state, were audited by the FBI for NCIC UNSOR compliance, which is a specific subfile of the NCIC database, which is used by law enforcement around the country. We do yearly questionnaires. So we send out information. We ask questions to get details about how people are doing things or what they have interest in or what training needs they have, emerging issues, for example, those types of things. We also track numbers. So this is a very numbers-based process. And so we're looking at numbers and we're making sure that we're performing as best we can. We're looking to make sure that all data is entered into the system as it should be. And if it's not, we're working with this committee and with local law enforcement to make improvements. We also try to improve the Offender Watch application, which again is the state registry. We have two pieces to that. We have an administrative piece that is our use, local law enforcement use, and then we have the public piece. But again, it's one database with kind of two different faces, if you will. And then we also do tons and tons of training. We have remote training, so I'll show you a couple of those here in a second. We have monthly open office hours. We'll go through that. And then we have annual in-person training as well. So these are our remote trainings. These are open, frankly, to anybody that deals with sex offenders. Predominantly, our audience is local law enforcement that does registration, but we certainly have individuals from the federal level that participate in these or attend these. We have individuals from prosecutor's office that attend these. We have supervisors, so probation, parole, community corrections. We've had some therapists on this. So I occasionally do presentations for the DOC SOM program. I have done some stuff for Miniso, if some of you may be familiar with that, a local group out of the Indianapolis area here as well. And occasionally we do get therapists that attend these trainings. But these are the types of trainings we do throughout the year. These are the ones we have remaining on the list, but we had these starting from January going forward. So initially, this list was much, much longer. All of these are web-based. They're all done through Microsoft Teams. They're each about an hour, and then we'll just simply give details and go from there. If anyone is interested in these and you happen to be law enforcement, we can give you ongoing training credit for law enforcement, and we do that through the Indiana Sheriff's Association. So we have a partnership with them to provide law enforcement officers training credit hours if they do attend these trainings. In addition, we offer office hours each month. We set aside an hour and we invite all of our folks that either attend these trainings or that we work with from a local law enforcement level. They can ask any questions they want. So if you think of it this way, it literally is open office hours like you would see in a university where your professor is in the office and you can come in and you can ask him or her anything you want, obviously in theory, dealing with the course you're attending, right? And you can do that for registration efforts as well. So we get questions all across the board, just all over the area of people that have specific questions and they don't want to wait for a training and they just want additional information. So we do offer that service. And then the final piece of our training efforts, we do put on in-person trainings. You can see all of those actually have happened except the last one, which is tomorrow in Henry County. So we do put on in-person training. Again, law enforcement can get credit for attending these trainings through the Sheriff's Association. But these trainings are meant to help our local sheriff partners understand registration, become aware of new emerging issues. For example, that recent court case on Peters, and just a bunch of other issues and areas just to help them improve their efforts. So again, we will be doing a training tomorrow at the Henry County Sheriff's Department, again, predominantly for local law enforcement. However, we certainly have had supervisors attending these, probation, parole, community corrections. We've had a couple judges attend these. We've had a few prosecutor folks attend these. Certainly, these are trainings that are ongoing. Again, our series will end tomorrow, but we'll be doing the same type of thing next year as well. Again, we offered 6 locations this year. Heck, we might go up to 8 or more next year. The idea there is we want to make it convenient for the people that work in this area around the state and hopefully attract more people from their communities. So I do have just a couple quick questions I'll go through here. I think we only have a few minutes left. Just real quick here. So no big detail, but I'll just kind of hit on these points because I think they're important. So what is the purpose of the registry? I mean, why do we even have a registry? So historically, registration systems had 2 purposes, and those 2 purposes are still the same today. The 2 purposes was one, to provide local law enforcement in your community with information about individuals that committed sex crimes and were living or somehow connected to your local community. So it's providing information to local law enforcement so they can be aware of individuals in their community. The other purpose is to provide public information to empower you, to empower victims, to empower just frankly anybody in their local community or in a local community, empower them, provide them the information so they can make their own decision. You should be able to make your own decision on whether or not you want to go to a restaurant that hires sex offenders that serve tables or work in a kitchen. I don't know if that's right or wrong. I shouldn't make that decision for you. You can make that decision yourself, and you can see that information on the registry. Do you want to allow your kids to walk down a certain street? Again, you should be able to make that decision and see the individuals that have been convicted of sex crimes and required to register, and you can make that decision. So the 2 pieces really are providing information to law enforcement and empowering people to make their own decisions. This system is not meant to reduce recidivism. That's the common statement today that, well, registration systems don't reduce recidivism. It was never meant to do that in the first place. It has nothing to do with recidivism. It's about providing information to people. So risk versus code. So many states will have their registration system built on a risk model. So for those of you that may be familiar with like a static 99 or a stable 2007, I believe, or kind of an acute tool or whatever tools are available that have been validated for various sex offender populations. Other states will use that to determine who is required to register or length of registration. But that's the minority. There's not a whole lot of states that do that, but some do. And most of them have sex offender management boards. Here in Indiana, it's a code-based system. If you're convicted of a certain crime, you're going to be required to register. If it's a certain crime, you might be a predator, and elements of that crime are going to meet the length of registration. Right or wrong, who knows? People will buy into the risk side of this. People will buy into the code side of this. Again, there's probably positives and negatives to each, but I think I can say for our specific approach for code and using that code-based model, at the very least, 100% without gauging risk, we know the individual has committed a sex crime. And again, if you go back to the purpose of the registry to provide information, seems to be an appropriate model. So here in Indiana, we do have residency restrictions, employment restrictions, and school restrictions. So if an individual is an offender against children, which includes a sexually violent predator, there's dates that matter into this as well. So you had to be convicted of that offense after a certain date for this to apply to you. But certain sex offenders can't live within 1,000 feet of various entities, school property, youth program centers, public parks, and so forth. Certain individuals can't work in certain locations. And again, we went through that and certain individuals can't be on school property. And so if you're what we call a serious sex offender, which has restrictions from being on school property, that serious sex offender definition is under 3542.4, so you can actually read that if you look that code up. It will list a laundry list of offenses, and if you have been convicted of one of those offenses, you're required to register. You can't even go and pick your child up in a bus line. You cannot be on school property. You can't attend a sporting event. You can't attend an after school event on school property. So there are restrictions for certain individuals. Again, they don't apply to all sex offenders, but they do apply to certain sex offenders that fall under certain categories and have committed crimes on or after a specific date. And in this case, it's July 1st, 6 for employment and residency, and there really is no date for school restrictions. Ordinances. So local sheriffs can have an ordinance to charge offenders to register. Many do. There is a state code that lays out kind of the maximum amount of fees that can be charged. It can be up to $50 for a registration requirement, and it can be up to $5 for an address change. If a county has an ordinance, they have went with the maximum. So there are those requirements for offenders to pay for uh, their registration efforts with the local sheriffs. Again, this is an unfunded mandate. So this is something that this is a way for local sheriffs to recoup their cost. In addition to that, you could have ordinances for other issues. For example, ordinances to prevent individuals from being in a public park above and beyond, just simply working there. Some individuals, based on an ordinance, can't be in a public park. There's examples of those, for example, in Hendricks County. They have those. I've just seen recently a couple of communities have ordinances to prevent sex offenders from turning on lights or being in certain locations around Halloween. So there are various communities around our state that have created ordinances to prevent certain individuals from being in certain locations. So unusual registrations, special needs, language barriers, as you can imagine, it's not as simple as it sounds, right? So you might have an individual that's bedridden, maybe the individual's in a nursing home, but yet that individual can't, or that individual is obligated by Indiana code to report in person to the local sheriff's department. Obviously, that's not happening, right? So there are various situations where your local sheriffs have to make decisions that are practical, right? And in that type of a situation, the practical decision is to go to the nursing home and register the person. Even though he's obligated to do it in person, he really can't do that. Another situation very similar to that is maybe somebody's in a mental health treatment facility. Can't really leave, right? And so the only way to get them to register is to actually go to that location. We also have individuals with special needs. Maybe they have, educational or mental health challenges or performing types of challenges, those types of things. We certainly have many individuals that speak other languages. English is not their first language, so we have to deal with those types of things. We've had to deal in the past with individuals that are sight impaired and certainly hearing impaired. Bottom line, for those latter categories, we have to accommodate ADA requirements, right? We have to make accommodations. And so your local sheriffs have to do that. So there are situations where they have to be creative, but there are many situations where they are obligated, not only by Indiana code, but federal code as well, to meet and accommodate ADA requirements. And the final item I just wanted to touch on real quick, and I've mentioned this a few times, there are tons and tons of court orders, modifications, set aside things. Really, bottom line, without going too much into detail here, you may have individuals that look very similar, yet one has an obligation to register, another does not. Facts matter, right? And to truly understand why the individual does and why the other individual does not have an obligation, you really need to look at those facts. It's very convoluted. It's based on Indiana code. It's based on case law. So with all that said, I will jump, I think, here to my final slide. A listing of this, and this will be provided to the ICASO folks to distribute so you can see all the different statutes that are related to registration. But if you have questions, you're always feel free, reach out to us so we can get you in contact with the right folks. I would encourage you to reach out to your local sheriff's department, ask to talk to the sex offender registration coordinator, sex violent offender registration coordinator. But if you have questions that you want to direct to us, you can certainly reach us by that phone number or that email address. This applies not only to this piece of it, which is the sex and violent offender registration piece, but it also applies to the victim services piece as well. We all work for the same division. So again, this may be an SVOR at email address, but in reality, we get victim services types of questions there. So I'll throw that out. My final kind of statement is if you have any questions about this or DOC in general and you don't know who to contact, feel free to contact us and we will help you out. With that, I don't know if there's any remaining questions, but I think that's the end of my presentation.